Political Science 100. It is time to take on the next section of the class, and that is civil liberties and civil rights. The text addresses civil rights first and then civil liberties. We're going to go in the opposite order, no matter. And first I want to talk a little bit about what the two are and what the difference is between them. You know, the fundamental notion of democracy is rule by the people, usually meaning rule by a majority of the people. But there are some things about which we want to prevent majorities from running roughshod over the rights of individuals and groups. Sometimes we want to protect the rights of individuals and protect the rights of groups in terms of being treated equitably in our society. And so that's what civil liberties and civil rights are all about. We want individuals to enjoy some basic rights and freedoms, and that's civil liberties, and we want groups to be treated equally, which is civil rights. And the difference between the two can be kind of confusing. In fact, I just used the same word, rights, to describe both. Both are about rights. Civil liberties are about individuals' exercise of their basic rights and freedoms. Civil rights is about groups being treated equitably in terms of enjoying the rights and privileges of society. So there's a lot of overlap in terms of the language you use to talk about both. One way to keep it straight is to think of that difference, two distinctions really, individuals versus groups, and the role of government in each. With civil liberties, we're talking about protecting individuals from government suppression of our rights. So liberties are about individuals' rights, and we want government to stay out of them, to not suppress them. With civil rights, we're talking about groups in society, groups that don't have the same rights and privileges of other groups, and government stepping in rather than staying out, government stepping in to protect these groups that don't have the same political power as other groups. So liberties are about individuals and individual rights, and we want government to not suppress them, so government stays out. Civil rights are about groups being treated equally and government stepping in to ensure that that's the case. So taking on civil liberties first, some of the main things that we're going to talk about in this particular chapter are the nationalization of civil liberties in the United States, how civil liberties came to be protected on a national level rather than because of issues that arose from states not respecting civil liberties. And we'll talk about the specific steps that led to this, to the protections of civil liberties. We'll talk specifically about our basic civil liberties, which are generally categorized as the four freedoms and potentially a fifth freedom, a couple of other amendments, and then the rights of criminal defendants. And at the very end, I'm going to make an argument that perhaps the world as the founders understood it back in the early 1790s when the Bill of Rights was added to the Constitution, maybe we need some updates there. So, when we talk about civil liberties, we're referring to the Bill of Rights, which is the first 10 amendments to the Constitution. So specifically, and the book listed these in the chapter on the Constitution, so I'm listing them here, whichever is fine. The first amendment to the Constitution is the four freedoms, the rights that we have to free speech, free assembly, press freedom, and religious freedom. And potentially a fifth freedom, privacy? Who knows? We'll talk about that. The Second Amendment is about the right to bear arms, and we'll talk about that as well. The Third Amendment is the amendment that prohibits quartering soldiers in your home. During the course of the Revolutionary War, the American colonists, some of them, were forced to house, to quarter soldiers in their homes. You can imagine the imposition that would have been to have to put up and house enemy soldiers in your home. So that was such a big deal that we have an amendment in our Constitution that says that the government can't force you to do that. Then we get to the rights of criminal defendants, the Fourth Amendment right against illegal search and seizure without probable cause. Fifth Amendment rights have to do with our rights in criminal cases, not having to self-incriminate ourselves, no forced confessions, no double jeopardy, which means you can't be punished for the same offense twice. The Sixth Amendment also refers to rights, but also in this case in terms of involvement in a trial, that you should have a speedy trial, you should be able to have a jury of your peers, you should be able to confront witnesses. And the Eighth Amendment is a ban against any kind of cruel or unusual punishment. And you might be saying, wait, you forgot 7. I didn't forget 7. But you're saying, well, yeah, you did. It says 4, 5, 6, and 8. Where's 7? We'll talk about 7 later. And then lastly, the Ninth Amendment says this list is not exhaustive, meaning these 10 things that are listed here in the Bill of Rights, they're not meant to be construed as the only liberties and rights that we might have. There could be others that the founders didn't think of at the time that belong on this list. And then lastly, the 10th Amendment is the one we've already talked about, the States' Rights Amendment, saying that the powers not explicitly given to the federal government are reserved to the states. The Bill of Rights was insisted upon by the Anti-Federalists in the context of the ratification battle over the Constitution. The Anti-Federalists worried about a national government that would be abusive of these rights. The founders didn't think it was necessary to include a Bill of Rights in the Constitution. It wasn't in the original document. And going back to something I said before in the discussion about the Constitution, the notion that the Constitution exists to protect we the people from tyrannical government, I argued that's not actually the case in the Constitution video. I actually argued that the point of our Constitution was to protect the government from we the people, from selfish, impulsive mobs of factions, us, from taking over control of government. There's really no better argument, no better evidence that that's the case than the fact that the founders didn't want to include the Bill of Rights in the Constitution. It's not in the original document. The only place in our Constitution where we the people, our rights are protected from abuse of government is in the Bill of Rights, and the founders didn't put that in the original document. That wasn't part of their plan. They were forced to add it as a concession to the Anti-Federalists in order to gain approval of the Constitution, or in order for it to be ratified. So it's hard to argue that something that was a complete afterthought was actually the main intent of the document in the first place. It doesn't make any sense. It's not that the founders didn't think these rights were important. They didn't think it was the federal government that was going to be abusing them. That was their reasoning. They figured it would be the states, and they were right. Prior to the mid-1800s, it was the states that were denying speech rights and assembly rights and religious freedom. It wasn't the federal government doing it, it was the states doing it. And the states went on their merry way doing so, arguing that the Bill of Rights, the first 10 amendments of the Constitution, that those applied to the federal government, not to them. Exactly what the founders worried about. So, thus began a long process of applying the Bill of Rights to the states, forcing the states to understand and recognize that the Bill of Rights applies just as much to state governments as it did to the federal government. And there were two main tracks upon which this proceeded. One was the ratification of the 14th Amendment in 1868. This is the amendment that was ratified in the aftermath of the Civil War to grant citizenship rights to former slaves. And so that was the main point of the 14th Amendment. But also included in that amendment is this language: nor shall any state deprive any person of life, liberty, or property without due process of law. This is known as the Equal Protection Clause, meaning that all people are equally protected in terms of the observance of their rights and protection of their basic rights and liberties. And that language about nor shall any state deprive any person of those rights, that is specifically saying to the states, the Bill of Rights applies to you too. It's not just applicable to the federal government. Even after that, however, and in fact about 100 years after that, we've had the second track upon which the Bill of Rights were applied to the states, and this is known as selective incorporation. And this refers to a series of Supreme Court rulings during a particular era of the court in the 1960s, in which the court issued decisions that basically meant that states must respect individual civil liberties. And these decisions proceeded on a right-by-right basis as cases came up in which the states were violating these rights, and the aggrieved party took the state to court. It went through the judicial process, and we'll talk about when we get to the section on the courts. And ultimately, the Supreme Court issued a ruling that basically meant these rights that are encapsulated in the Bill of Rights, the states must respect those as well. In the text, there's a large chart with a long list of cases that are part of this process of selective incorporation. I've listed just a few here, one of which I'm sure you're familiar with, the Miranda rights against self-incrimination. Any police drama or movie you've seen where an arrested person is informed that you have the right to remain silent, anything you say can and will be used against you in a court of law, blah, 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 blah. That statement and the requirement that law enforcement inform people of that right upon arrest stems from the 1966 Miranda versus Arizona case, in which the state of Arizona was arresting people, including a man named Miranda, and not informing them that they don't have to incriminate themselves, that they don't have to talk to the police, that they can keep their mouths shut. And so Miranda did talk and said things that incriminated him. The right to remain silent is now respected as a national right, a basic civil right that all states must respect because of the Supreme Court ruling in the Miranda case. There was a similar ruling in the MAP 1961 case involving search and seizure, the right to counsel, and Gideon versus Wainwright. The point being, over the course of a series of Supreme Court rulings, predominantly in the 1960s, the individual rights that are encapsulated in the Bill of Rights were decided in these court cases as applying to the states. So through these two processes, the 14th Amendment, which should have been enough, I mean, that's a pretty blanket statement, but it wasn't. So, and then subsequently through selective incorporation, the states came to understand and recognize and honor the reality that the Bill of Rights applied to them as well. Okay, let's talk about these specific rights that are in the Bill of Rights. And in much of the discussion that's to follow, I want to sort of talk about a basic tension between our exercise of our individual freedoms versus what's in the best interest of society, because that's really the balancing act that we as a society and as a country face. We want to have these rights and freedoms, but none of them are absolute. There is a point at which the exercise of our individual rights can go too far and can be and can jeopardize the greater good to an extent that we're not okay with. You know, we are free to speak, but there are some things you can't say because they pose too much danger to the greater good. We are free to worship as we choose or not at all, but not everything is allowed in terms of accepted religious practices, which raises the question, where's the line? What is the right balance between allowing individual freedoms versus limiting them in some respects in the interest of the greater good? And the analogy that usually is used here is you can't yell fire in a crowded theater. And I don't find that particularly helpful. That's too obvious. Of course you can. People will panic and flee, running out of the theater, and someone will get trampled and hurt, possibly killed. Of course you can't do that. I want to talk about something that's a little perhaps less obvious. In the spring semester of 1996, which was only my second semester here, I was hired in fall of 95, on a beautiful, was it Tuesday or Thursday? One of those two. Afternoon, classes let out in the middle of the afternoon, and students were streaming to their cars in the main parking lot, the same main parking lot that we have on campus today. And when they got to their cars in the parking lot, they found these flyers under the windshield wiper of their cars. So posted on the cars in the student parking lot were all kinds of blatantly disgusting, racist flyers. You have to understand that this was the early years of this university, and this was a university established in North County, San Diego, with values like multiculturalism and diversity embedded in our mission and our values. There was a guy named Tom Metzger who lived in Fallbrook, and he was a blatant white supremacist, a white nationalist, and he headed an organization of white nationalists that was based in Fallbrook. And a bunch of his acolytes basically came to campus and stirred up all kinds of trouble. We became an instant target because of our values of things like multiculturalism and diversity. We became an instant target for these white nationalist hate groups. And one of the things they did was disseminate these flyers, and this is just one of them. This is an actual one that was on the cars. There were many others, but after this happened, I went to the university police and I got a copy of one of these to use as an example in this class. Is this protected speech? Is this kind of expression what the founders had in mind in terms of protecting the rights of our free speech rights? Is this allowed? If not, why not? What's the line? Where do you know when something has crossed the line from being protected to being not protected, to being not in the interest of the greater good? Clearly this is disgusting. Clearly this is blatantly racist, ignorant, hateful. A number of other words come to mind. But is it protected? The university arrested 2 individuals in connection with distributing these flyers, and we wanted to press charges. So we consulted the district attorney's office at San Diego, and we were told that this is protected speech. Even though some of these, so basically the DA's take was, is there an explicit incitement to violence in these messages that is beyond what's allowed in terms of free political expression? There's stuff that's close. This line over here about harassing people out of here, that's pretty close to an incitement to illegal activity. But it's just vague enough. It's just not explicit enough to cross the line, according to the district attorney's office. This was considered to be protected speech, despite it being hateful, despite a reasonable person imagining that you might look at this and react angrily and perhaps violently. So this could incite violence. But it's not. The crafters of these messages, as ignorant as they are, they're also clever enough to have an idea where the line is. Interestingly, after the university was turned down on the grounds of the content of the speech itself, they came back with a second idea. Can we arrest these people for littering? Many of these flyers ended up on the ground, so that's littering. Okay, that seems straightforward. It's kind of like getting Al Capone for tax evasion. That's not really what you wanted to get him on, but if that's what you got, okay. The DA's office came back with a question. Have other groups ever distributed flyers on the windshields of cars at your university? Oh, yeah, they have. Did any of those flyers end up on the ground? Oh, yeah, they did. Did you charge them with littering? No, we didn't. So what's the difference here? It's really the content of the message you're not liking. It's not the littering. So no charges were pursued in connection to this. To me, that's a much more difficult and realistic example of what is and is not protected speech, and the difficulty of these kinds of cases in deciding whether something is or is not protected. Similarly, we have the right to assemble. The right to assembly means the rights of groups to get together, like-minded people, and get together and express their political point of view, to petition government, to convey as a group their feelings about public policy. Is this protected under the rights of freedom of assembly? The text talks about this, and there's a different picture. This is the Westboro Baptist Church, based in Kansas. It's a small church. It's by no means some large denomination. It's basically a single family and its associates. But they have a view against homosexuality, and they believe that war deaths are God's punishment to America for allowing homosexuality. Hence the nature of these signs. And not only do they have that view, they express that view by going to the funerals of fallen soldiers, Americans killed in war, and assembling in the vicinity of those fallen soldiers at their memorial services to express the view that God killed them because of America's tolerance of homosexuality. Is this protected assembly? You can imagine the feelings, the grief of family members who are grieving their loved one, the dead soldier, how they must react to seeing messages like this in the vicinity of their memorial service. It's got to be horrible. The Supreme Court ruled unanimously that this is protected assembly. They did issue some rulings that this assembly this specifically has to be confined to an area a certain respectful distance away from the actual memorial service itself. But this is, in fact, protected speech. Again, this is the kind of thing that's difficult to tolerate. But what I would say is the easy stuff, the speech in the assembly that we all agree with, those are not the test cases of our commitment to civil liberties. Of course, everyone supports speech that is uncontroversial and not challenging and not inoffensive. It's the offensive, repulsive stuff that must be protected if we're going to live in a free society. Up to a point, of course, there are limits on that, but neither of these cases, according to the courts and law enforcement, cross that line. If you disagree, I understand. I find this one myself hard to accept as protected speech. This looks to me like hate speech designed to incite violence. This is repulsive. It's not easy to stomach this stuff. But those in power have declared that this is the kind of stuff that you have to tolerate in a free society, or you're not really a free society. Another of the four freedoms is the freedom of the press. The role of the press and a free press in a democratic society is huge. It's fundamentally important. Citizens have to know what government's doing in order to be able to meaningfully and in an informed way render their support for the government and its elected officials or oppose them. Without information from the press, that can't happen, and we can't have government censoring the press, prohibiting the press from publishing things that government doesn't approve of or doesn't want us to know. Okay, that's easy to say. Does that mean that the press can publish classified documents, government secrets, if they can get a hold of them? This, of course, is Julian Assange, and he is the founder of WikiLeaks. WikiLeaks is a website in which Assange and others have obtained classified materials and put them online for everyone to see. The initial burst of materials had to do with our government's handling of the war in Afghanistan, and a lot of information, a lot of stuff that the public didn't know that reflected very badly on the U.S. government about how we conducted the war and how the war was actually going. Is this kind of activity protected under the rights of a free press? Is exposing government secrets the fundamental role of the press, or is it basically espionage? Assange right now is facing charges under the Espionage Act for what he published in WikiLeaks. Just last November of 2022, several major news outlets, including the New York Times, sent a joint letter to the U.S. government warning that, as the article says here, warning that the indictment of Julian Assange sets a dangerous precedent that could chill reporting about matters of national security. So again, there's the line. Is it in the best interest of society that we know everything that government is doing, and so we need the press to let everything out? Or are there some things that are too sensitive that the press does not have the right to publish? It's not altogether clear. There's no hard and fast answer. There's no clear line of demarcation between when the press is doing its expected role in democracy and when it's gone too far. And the final freedom is the freedom of religion. Well, is it the final freedom? Hold off on that point. The fourth freedom is the freedom of religion. And there are two elements of religious freedom. One is the free exercise of religion. So religious practices are to be allowed. You should be able to exercise your religious preference and all its practices freely without interference from the government. And the other is the establishment of religion is not okay. Government cannot establish or preference any one religion or over any other religion. Well, in terms of the free exercise of religion, does anything go? Sorry for the gross picture, but this is a picture of animal sacrifice in the religious practice of Santeria. Is this a protected religious practice? Is it? I mean, to my eye, it's awfully gruesome. It's probably cruel, it seems to me. Is that protected under the Bill of Rights as a religious practice we're okay with? In one city, I believe it was Milwaukee, Wisconsin, a group of people sued to stop animal sacrifice as a religious practice. And in the course of the lawsuit, the attorneys representing the religion, Santeria, they got into the differences between how animals were treated at the local butcher shop versus how they were treated in the course of the religious practice. And it became very clear that the treatment of the animals in the religious practice was much more humane than their treatment at the local butcher shop. And yet nobody was protesting, trying to shut down the butcher shop. Clearly, again, the objection was not so much the cruelty to the animals, but it was targeting the religion. And the courts dismissed that suit as a violation, an attempted violation of religious freedom. This is considered an acceptable religious practice. There are others, though, that have been regarded as unacceptable. The use of peyote, a drug, an illegal drug, in certain Native American religious ceremonies has been ruled illegal, is banned. You might be wondering why the use of drugs is not okay, but killing animals is okay, and I get it. It's a good question. Again, in all of these things, there is no clear and obvious dividing line. There's no simple formula you can plug things into and get your answer. They're all very tough calls. As far as the establishment of religion goes, this is a little closer to home. This is the cross on Mount Soledad. Mount Soledad, you've probably been there. It's in the La Jolla area. It's up on a beautiful hill. It's a war memorial. And so all of this gray area here are individual plaques honoring people who've died in wars over many years, going back at least as World War II and subsequent wars. And some of these people were Christians, some of them were not Christians, some were, and many kinds of faith are represented here. So what's the issue? Well, the issue is this. The Christian cross is, of course, the preeminent symbol of Christianity, and it is the predominant symbol on this war memorial that is on public land. Is this not establishing or preferring one religion over others? And of course, we could have that conversation on many grounds involving normal practices, routine practices in American life. Congress opens its sessions with a prayer. We typically swear in elected officials on a Christian Bible. We have "In God We Trust" on our currency. What is that okay? Are these elements of religious life in our political and our political life, are they allowed, or do they violate the Bill of Rights prohibition against establishing one religion over another? And there have been a number of court cases in which the courts have ruled that you can't do that. There was a judge in Alabama who had a statue of the Ten Commandments in his courthouse. He was ordered to remove that. There have been prohibitions against school prayer and other kinds of exercises of religion. And we've tried to find ways to dance around these kinds of things. Some schools that allowed school prayer have instead asked for a moment of quiet reflection, in which some people could pray if they wanted to, and people who aren't religious could just think quietly to themselves. Is that okay? There was a movement involving this cross, Mount Soledad. There was a movement for a time to sell just the land around the base of the cross to a private party, so that it wasn't technically on government land, as an attempted workaround against the objection of a particular religious symbol on a public memorial. And the courts struck that down as an obvious dodge. Again, what's your view on this? Is your view that, look, it's a war memorial. It's a benign. It's nothing offensive about this cross here. Just let it go. Relax, people. Or is your view, look, if you start allowing these kinds of things and you don't raise the objection, it's a slippery slope until we have the establishment of a dominant state religion, which is the exact thing that the language of the Establishment Clause in the Bill of Rights is designed to prevent. It's the thing that led the original American colonists to leave Britain and the Church of England to come and pursue religious freedom in the United States in the first place. So no, it's not okay. I'm not trying to tell you which view you should have. The point I'm making is that these are difficult calls, and these are the kinds of things that continue to divide and continue to brew as issues in terms of our civil liberties. Is there a fifth freedom? Is privacy a protected right? It's not mentioned in the Bill of Rights. There's no specific mention of the word privacy. There are some things that are kind of close. The idea behind the Third Amendment, a prohibition against quartering soldiers, seems to be government needs to respect the sanctity of one's home, the privacy of one's home. So you can't be forced to put up soldiers in your home if you don't wish to. Also, the Fourth Amendment prohibition against illegal search and seizure likewise seems to be about respecting the privacy of one's person against invasive searches by officers of the state, the police, the court, anybody else, without some good reason to engage in some kind of search. So privacy seems to be implicit in that, but it's not specifically stated. I would also add, however, the Ninth Amendment, which says that the list of rights in the Bill of Rights is not exhaustive. That's not the be-all and end-all right. So the founders themselves understood that there would be other rights that perhaps ought to be recognized, and just because they're not listed there doesn't mean they don't exist. So the right to privacy was established as a constitutional principle in the 1965 court case, Supreme Court case, and this is part of selective incorporation that I referred to a moment ago, that overturned a Connecticut state law that banned birth control, even for married couples. The courts ruled that the Bill of Rights implied a right to privacy from government interference on such personal matters as that. It was this precedent, the Griswold case, that was the basis for the 1973 Roe v. Wade case that cited privacy as including the right of women to make their own reproductive choices. So as of 1973, with these two cases, it was assumed that we did have a fundamental right to privacy as part of our civil liberties. And this privacy right was then extended as the basis for legalizing same-sex marriages in a subsequent court case. Okay, except all of that came to a head and was undone with the reversal of the Roe v. Wade decision in the court case in 2022 that invalidated Roe and basically threw the question back to the states in terms of whether abortion was a protected right. And the fundamental argument made against Roe is that the privacy right that it is based on, established in Griswold, is not in the Constitution. And so to say that it is constitutional and that's your basis, the majority on the court that issued this decision in the summer 2022 said that there is no privacy right. It's not in the Constitution. So there you have it. Do we have a constitutional right to privacy? Some say no. Justice Samuel Alito, who wrote the majority decision in the 2022 court case invalidating the Roe decision, tried to argue that his logic here was limited to abortion rights and should not be extended to any other rights, such as rights to same-sex marriage. I don't see how that argument can hold up. If the right to privacy is the basis for one and he's invalidating that because the right to privacy doesn't exist, how do you then not say that these other rights that were based on the same right to privacy that he said doesn't apply in Roe somehow don't apply there? And so there are many who are concerned about attempts to invalidate same-sex marriage rights that are based on a privacy right. Again, I'll point out that the Ninth Amendment to the Bill of Rights seems to cover this, that a right doesn't have to be specifically mentioned in the Constitution to be a right. That's what the founders meant. That's what they said in including the Ninth Amendment among the list of amendments. But again, these are the kinds of decisions that divide society, and they're ongoing issues. They have been since the founding, and they are today. The next section of rights has to do with the rights of criminal defendants. So these are the rights that you enjoy, that you can count on, hopefully, to some extent, if you're ever in the context of the criminal justice system. And that doesn't have to mean that you're arrested or you're on trial. It does mean that. But anytime you're within the grasp of the criminal justice system in any sense, that means driving down the street past a police car. That means anytime you're pulled over. It means any way in which you have contact with law enforcement or criminal justice, you have some rights. And here again, we're dealing with the tension, the balancing act between our individual protections, our individual enjoyments of these basic civil liberties versus what's in the best interest of society. We could live in a much safer society if we suspended many of these rights. If you want to live in a really safe society, it's not hard to figure out how to do it because there are police states that do these kinds of things. Excuse me, voice going out. We should simply install surveillance cameras everywhere and have government officials monitoring them at all times so that everything you do is on video. We should allow the government to access to all our emails, all our text messages, all our online activity, everything. They can just see all of it at any time. We should give police broad powers to stop and searches at any time for any reason. Just pull you over and ask you some questions, search you, look in your car, look in your home, just 'cause I feel like it. We should lower the standards for arresting people, the evidentiary standards. I'm going to arrest you. I think you might be up to no good. We should remove all those burdensome procedural requirements during trials, having to confront and be able to cross-examine witnesses and being represented by competent counsel and having a speedy trial. Let's just throw people in jail for a long time and, we'll get to them eventually. And when we get to them and we decide that they're guilty because we don't really have any evidentiary standards anymore, we just convict anybody we want, then we should punish them in the most brutal way possible. We should hold public executions, and we should make them really gruesome. If you do all that kind of stuff, crime will definitely go down in society. You'll also live in a police state. You'll also live in a society that not many of us would recognize as free. So if you don't want to live in a police state, that's the point of having all these due process rights for criminal defendants that are consist of the 4th, 5th, 6th, and 8th Amendments to our Constitution. The 4th Amendment prohibits illegal search and seizure. The state can't simply search you without a good reason. Okay. Pictured here on your screen is a DUI checkpoint. Is that not a violation against illegal search and seizure without probable cause? One Christmas some years ago, I was driving on Coast Highway. I was heading south in Encinitas, and I had just passed Swami. So I was on that long stretch between Swami's and Cardiff, basically. And I came across a DUI checkpoint. So I got in line with the rest of the cars in the checkpoint. And when it came my turn to be up to the officer where the stop sign is, approaching here, I rolled down my window. And next thing I knew, the officer's head is basically in my car. That was a surprise. He was smelling. He wanted to smell if he could smell alcohol on my breath. I hadn't been drinking. So no, he didn't. And a few minutes later, I was on my way. My question is, what's the probable cause here? That was a pretty invasive search. My car was pulled over. I had a law enforcement officer with his head in my car smelling around. It was pretty invasive. What did I do? There is no probable cause here. It's one thing if a person is driving erratically, weaving all over the road and clearly impaired, then pull them over. But what is the argument for these DUI checkpoints? Well, the argument is that there's a lot of drunk driving that happens and a great deal of damage is done, and loss of life and property damage and injuries. And it happens more sometimes than others, including at night around the holidays. And so law enforcement sets up random checkpoints and tries to get people. I looked the next day in the papers, and there were a number of people who were arrested at that exact checkpoint. So in all likelihood, it's quite possible that that particular DUI checkpoint saves some lives by getting drunk drivers off the road. So there's what's in the greater good of society. But then there are my individual civil liberties that were violated here. Is this okay? Again, I'm not trying to tell you one way or the other, and you can make up your own mind about whether these kinds of searches are justified or not. I'm just pointing out the tension that exists between how we conduct ourselves and what we accept as a society and what the 4th Amendment allows and doesn't allow. The 5th Amendment prohibits self-incrimination. You don't have to testify against yourself. You can't be forced to confess if you're charged with criminal matters. And there's no double jeopardy. You can't be tried for the same offense twice. If you're arrested and tried for an offense and you're found not guilty, the state can't then say, okay, we're going to try again. Because if they could, The state could simply then keep trying you until they finally got a jury that bought it, whatever evidence they have, and convicted you. So the state gets one shot at you, which is why I have two pictures of O.J. Simpson on the screen. One is happy O.J., and one is much less happy O.J. Happy O.J., this was in 1996, I believe it was, when he was acquitted of the murder of his wife and her friend. Sad O.J. was O.J. being found civilly liable for the death of his wife and her friend. O.J., how can that be if we have no double jeopardy? Once O.J. was acquitted in 1996 of the crime, how can we go after him again later for the same crime? Well, this was a criminal proceeding in which he was acquitted of murder, but this was a civil proceeding in which he was found responsible for her death and the death of her friend. Technically, they're different proceedings. The evidentiary standards are different. This is beyond a reasonable doubt, and this is a preponderance of the evidence. And the jury here found him not guilty beyond a reasonable doubt, and the jury here found a preponderance of the evidence suggesting he was responsible for their deaths. Is this a violation of the prohibition against double jeopardy? I'm sure O.J. thought so. Is it? You decide. The Sixth Amendment involves the rights that we have in the course of being tried for criminal offenses. So you have the right to counsel. You have the right to a speedy trial. You have the right to a jury of your peers. So this is to avoid things like people being unrepresented and not having the wherewithal and the knowledge to actually represent themselves in an effective way in the criminal justice system. This is to prevent the state from simply locking you up and throwing away the key and hopefully someday getting around to trying. So basically, you're being punished for the offense before you've even been tried for it. And this is to enable those deciding your guilt or innocence to be fair-minded people and not the state weighing in with an obvious interest in convicting people if the state was the one arrested you in the first place. And the cartoon here is meant to convey that there are questions about all those things. Yes, we all have the right to counsel, but there are huge disparities in the effectiveness of counsel. Imagine a poor person who meets their public defender the hour before they go into court versus a person who can afford much more competent counsel and the luxury of a great deal of preparation and meeting time and billable hours with that counsel before their trial. The notion of a speedy trial is relative. The criminal justice system has a huge backlog. And so, you're not getting tried the next week if you're arrested and in prison for something. It's going to be a while. And a jury of your peers, well, there's a kind of a joke. I've served on many. I've been called for jury duty many times. I've served once that I can remember. But it's awfully easy to get out of a jury trial. If you have it tends to be people who have the time and the inclination who serve on juries, and a lot of people find ways to get out of it. So is that really a jury of your peers? And what do those peers look like? Are they the competent people that you would actually want, or are they the people who weren't smart enough to figure out a way to get out of jury duty? And then lastly, the Eighth Amendment is the amendment that prohibits excessive bail. So the government can't set a bail amount that is just so high that you couldn't possibly meet it, and so you're just stuck in jail. It also prohibits cruel and unusual punishment. And of course, the issue that we're talking about here most often is the death penalty. Whether or not the death penalty in any context should be allowed. And this has become a subject of renewed controversy with improvements in DNA evidence technology that have exonerated many death row inmates, and including some who were executed. And then, in addition to the question of whether or not the death penalty should exist at all, the method by which it should be employed. And we've seen multiple methods used over the history of the United States, from hangings to firing squads to electric chairs, and now, as depicted here, lethal injections. Whether any of those are not cruel and unusual is a subject to a great deal of debate. If I understand correctly, many states have had a hard time acquiring the chemical concoction to be used in lethal injections because so many companies who make those kinds of chemicals want nothing to do with their chemicals being used in the exercise of the death penalty. So, does this constitute cruel and unusual punishment? Is the fact that it's an irreparable punishment, that once it's meted out, you can't undo it, even if subsequent evidence proves that, in fact, the person that was killed, executed, was wrongly executed? Again, not my job to tell you, but think about it. Okay, so that's 4, 5, 6, and 8. I've been putting this off, teasing this for a while. What about 7? Why have we not talked about the 7th Amendment? Well, I didn't forget it. Here's what it says. In suits at common law, where the value in controversy shall exceed $20, the right of a trial by jury shall be preserved. What the founders were going for here was to make sure that we had a right to a trial by jury, not just for criminal charges, but for civil charges. Criminal charges involve suspected violations of criminal law. Civil lawsuits are about disputes over things like contracts. People feel they've been wronged in some way, not by the commission of a crime, but by the violation of some contract or expectation. So, fair enough, the founders wanted to have an amendment that made sure that it was established in our Constitution that in those kinds of court disputes, you also have the right to a trial by jury. Great. What's the problem? They set a dollar amount. They wanted they didn't want the courts to be flooded with trivial disputes between citizens over civil kind of issues. So they wanted to set a really high dollar amount so that it'd have to be something that was really important in order to take up the court's time with a trial by a jury. So they set it at $20, which apparently in 1791 when they did this was a lot of money. It's not a lot of money today. $20. I mean, it'd be impossible to go out for happy hour with a group of friends and get into a dispute about who should pay what on the bill, and that not be about $20 and more. I mean, you couldn't do it. So do we want every argument among friends about how the happy hour bill should be divided up to end up in a jury trial in a court? Of course not. But that's what the 7th Amendment means, which is why we don't talk about it. It's basically a dead letter, which is weird language for a document that exists in writing, but no one pays any attention to it anymore because it's ridiculous. $20 in 1791, there are all kinds of online, what's the value of this amount today, sites you go to. And I went to one yesterday, and it said that $20 in 1791 is about $700 now. The point I'm making is that, the Constitution is a brilliant document in many ways. And we rightly respect the founders. I think sometimes we go overboard, though, in deifying them. They weren't perfect. They screwed some stuff up. I could do a whole video on things the founders didn't anticipate and didn't get right, such as the emergence of political parties, for example, that completely undid what they were thinking would happen with the Electoral College. A whole lot of stuff. There are many areas which I'm sure they would have wanted to do over. If they could live today and see how things have played out, there are things they probably would have changed. And I'm sure this is one of them. What worked in 1791 may not work today. Okay. And this is a point that there's an element in American politics today that likes to talk about a strict constructionist interpretation of the Constitution, that we should interpret constitutional questions today with exactly what the founders had in mind, the original intent of the Constitution, and that is somehow wholly and binding. And what we need to do to decide cases and decide constitutional questions today is to just discern the meaning of the founders. There is so much wrong with that point of view, including the fact that the founders themselves had very different ideas about how things should go. The two preeminent founders, the designers of the Constitution, James Madison and Alexander Hamilton, disagreed fundamentally about fundamental questions like the relative role of the executive, legislative, and judicial branches. So the idea that there's some single will of the founders that we can just discern and use that to decide things is absurd. But also stuff like this. They would not want you to abide by a $20 minimum for civil trials for a trial by jury. They got that wrong. And they would be, if they were alive today, I'm sure they would admit it. I'm going to make, that's fairly obvious. I'm going to make one other extension to this argument that you might not think is quite so obvious. To me it is, but again, it's not my job to tell you what to do. $20 in 1791 is not the same as $20 today. Nor are arms in 1791 the same as arms today. The Second Amendment is interpreted as the right of all Americans to keep and bear arms. Basically, anybody can have a gun. There's a lot of dispute about whether or not that's what the founders had in mind. It tends to ignore the first part of the preliminary language before that phrase about the right to keep and bear arms, which talks about a well-regulated militia. And there is a pretty strong argument, in my view, that what the founders had in mind was members of a regulated militia have the right to bear arms, which is not the same as anybody in the country, everybody having a right to bear arms. But even if you leave that aside, would the founders have meant that? Would the founders have intended that if they had known what arms look like today? The arms that I'm showing were the arms that existed in 1791. And pay in particular attention to this rifle. This was a single-shot rifle, and I know very little about guns, so this is not going to sound particularly informed. But as I understand it, this little piece standing out here from the bottom of the barrel of the gun was a rod, and so to load this gun, you had to take a bullet and some powder and put it into the gun and then stuff it down with that rod, and then you could fire. These guns, so you could fire one shot at a time, and then you'd have to reload, which took some period of time. These guns were not particularly accurate. They didn't have a great range. So think about how, and I'm sorry to get into this potentially upsetting topic, but think about how a mass shooting would go in 1791. A crazed person shows up with this particular rifle, fires a shot, and then what happens? In all likelihood, the person is overrun and subdued by everyone around them. Maybe the person got off one effective shot and hurt one person, and that would be it. Mass shootings pretty much couldn't exist with these kinds of arms. Well, here's arms in 2023. They're not the same. Would the founders have intended that same blanket statement, we have the right to keep and bear arms, if they had anticipated arms like these with massive firing capacity and much more ability to do damage and much greater range and much more accuracy? Would they have meant the same? Clearly they would not have wanted to set a dollar limit of $20 for the Seventh Amendment. Would they have said the same thing about the Second Amendment? Again, and last time I'll say it, not my job to decide these things for you, but I think it's worth thinking about. Okay, that's the conversation I want to have on civil liberties. We will turn next to civil rights.